finally got ourselves an appeal. At least the brief from Alec Murdaugh's attorneys outlining every error that they think was made during the trial of this case. And when I tell you it's long, it's 132 pages. Can't go over all of that with you, but I can hit the major highlights. Excuse the reading glasses. Okay. About half of this complaint, if not more, deals with Becky Hill and the jury tampering, because that's a major argument here. She actually had conversations with the jurors. At least 3 of them testified that she had made comments about watching him when he testified, implying that he was not going to be honest. I think that's a major deal. And remember, we talked about the standard, the legal standard, being that Rimmer says that if you prove that there is any comment from the court staff, then the burden shifts to the prosecution to prove that it was not prejudicial. But in Green, that's the South Carolina case, they said, nah, this was innocuous. But in Green, that was like a question asked by a juror about what time they were leaving or getting pizza. I don't remember what it was, but something really had nothing to do with the case. This one does. I believe that Rimmer was the proper standard. She applied Green. We'll see who the Supreme Court sides with. Mind you, our Chief Justice of the Supreme Court actually wrote the Green opinion. Here's a couple of comments in the brief about the actual evidence itself. Like, there was very little physical evidence. They never found the rifle. They never found the shotgun. The blood on Alec's clothes were droplets, if anything, and there were no bloody clothes found anywhere. Also about the raincoat that was allowed in that had gunshot residue on it. The nanny for his mom, the housekeeper or caretaker for his mom, said that he carried in a blue tarp. She didn't say he carried in a raincoat. She was very adamant about it being a tarp, and they still let this raincoat come in. There was also an investigator who testified that the shell markings on the casings came from, the ones that were found in the shooting range matched those that were used to kill Paul and Maggie. And he never said that it had to have come from that gun or whether any other gun could have made those same markings. That's one of their issues. There was also an investigator who said he spent some time in his office tossing a cell phone around to see what would make it light up and come on, because that's how Maggie's phone was found on the side of the road. But he never wrote his results down. He never videoed the testing that he was doing. So why was he allowed to talk about that? He honestly should not have been allowed to talk about that. And of course, one of the biggest arguments that is going to be made is the fact that all of these financial crimes came in. I think it was 6 days of testimony that they're saying, all on financial crimes, when the prosecutor pretty much said that he was doing this for sympathy, not about his financial crimes, not that he was desperate. He said he was doing this for sympathy. So which one was it? And was it cumulative and bad character evidence that they just continued to allow in? Maybe that's part of the appeal. They talked about mistakes that were made by law enforcement. No attempt to lift the fingerprints on the door or anywhere in the feed house. There was also unknown male DNA under Maggie's fingertips. They didn't submit that to CODIS to try and identify it. They didn't place Maggie's phone in a Faraday bag, and therefore some of the data from the night of the murders was deleted or overwritten. And there was also 2 statements, we talked about this a while back, 2 statements by Agent Owens in the grand jury testimony for this indictment that were ruled to be lies. So we've got an extensive appeal going here, 132 pages. The state has 30 days to respond to this. Now, they'll ask for a continuance as well as they should, and they will likely be given one. But we're a long way down from actually hearing anything about this. The judge actually, or the Supreme Court justices actually have to go back and read this trial and read all of this evidence. So we're a long ways away from a hearing on this, but it is finally in motion.